My name is Willa. I am 31 years old, and I was on a plane back to Toronto for my divorce mediation when I helped an elderly man in the seat beside me. He said he was just a retired business professor heading home to see old colleagues. My husband laughed when he saw him limping down the courthouse hallway at my side. 20 minutes later, my husband's lawyer couldn't form a complete sentence. And the same judge who had already decided how this story was going to end, stood up from his bench like he'd been struck. Before I tell you the rest of this, let me know where you're watching from in the comments below. And if you've ever had to rebuild your entire life from the ground up after someone decided you weren't worth keeping, hit like and subscribe. This one's for you. I was sitting in seat 22A on an Air Canada flight from Calgary, somewhere over northern Ontario, when the message landed. I'd been out west for 4 days on a corporate fraud audit, an energy company whose books had been quietly bleeding for 18 months, and I hadn't slept properly since Tuesday. My back ached. The coffee from the airport Tim Hortons had gone cold in my bag, and then my phone lit up with my husband's lawyer's name. I opened the email. The offer was $15,000. That was the number his legal team had decided represented 8 years of my life. $15,000, Canadian, to walk away from a marriage I had spent the better part of a decade quietly holding together. The email noted that if I declined to accept mediation on those terms within 48 hours, they would proceed to trial and ensure the process extended long enough that my legal costs exceeded any realistic recovery. I set the phone face down on the tray table. I looked out the window at the dark flat of the shield below us, the lakes catching the last of the evening light. My husband had filed for divorce 3 weeks earlier. The timing had not been accidental. We'd spent 6 years building his real estate development company together, me working nights and weekends to keep the corporate finks clean, signing the loan guarantee paperwork, managing the quarterly reporting so we could keep access to our operating line. Last month, his biggest project, a 50-unit condo development in Etobicoke, had been approved by City Council. The pre-sale numbers had come back stronger than anyone expected. He handed me the divorce papers 4 days later. I opened my laptop. I'm a chartered professional accountant with a forensic specialization. Finding money that people would prefer stayed hidden is exactly what I do for a living. I went to the Ontario Business Registry and searched for numbered companies registered in my husband's name or his business partner's name in the 14 months before our separation. He'd been careless, or maybe he'd assumed that the fact that I was exhausted and heartbroken meant I was also stupid. There it was, 2847391 Ontario Inc., registered 10 months ago, with a registered address in North York I had never seen. I cross-referenced against the Provincial Property Transfer Database. A house in Oakville, a property worth at assessed value $1.4 million, had been transferred to the numbered company 7 months before he filed. The purchase had been funded through a draw on our joint corporate line of credit. My fingers didn't shake, there was no room for that, I just kept typing. The sound of something hitting the floor broke my concentration. The elderly man in the window seat had dropped his leather portfolio. His hands were trembling, his face gone a chalky, alarming gray. He was pressed back against the headrest, gripping the armrest, breathing through his teeth. A few passengers glanced over with mild irritation. Nobody moved. I unbuckled my seatbelt and pressed the call button in the same motion. I'd grown up watching my uncle manage his blood sugar badly at every family gathering for 20 years. I recognized a hypoglycemic episode when I saw one. When the flight attendant appeared, I told her exactly what I needed. "Orange juice right now, please, quickly," she went. While the man drank slowly, color returning to his face in gradual stages, I gathered the papers that had scattered from his portfolio across the narrow aisle. They were dense documents, financial schedules, case citations, columns of liability figures. I stacked them carefully without reading, but I am a forensic accountant. I cannot actually look at a liability column without seeing it. I set the last page down and looked at it for a moment. A depreciation table, a specific amortization rate in the third column. The number was off, not by much. Barely a fraction of a percent, the kind of error that reads as rounding until you trace it forward through 4 quarters and watch it compound into something that could cost the company it related to somewhere close to $300,000 in unnecessary tax liability. He was breathing steadily now, the trembling gone. "I'm sorry to intrude," I said, turning the page toward him and pointing to the specific figure. "But I think whoever prepared this depreciation schedule made an error here. If this rate carries through the full fiscal year, the liability figure will be materially misstated." He was quiet. He took a pair of glasses from his breast pocket and studied the table. After a long moment he said very quietly, "I've had 4 people review this document." "I know," I said, "numbers are easier for me than most things." He extended his hand, his grip was firm. "My name is Malcolm, just a retired business law professor heading back to Toronto to see some old students." He paused. "And you?" "Willa," I said, "it's good to meet you." The pilot announced our initial descent into Pearson. I was packing my laptop when my phone buzzed with a photo notification from a number I didn't know. I opened it before I'd thought to stop myself. It was a photograph of a hand holding a coffee cup. The hand was young, manicured, and wearing a ring I recognized better than I recognized my own reflection. A small oval garnet set in yellow gold, the band worn thin from 50 years of daily wear. My grandmother had brought it from Ukraine when she immigrated to Canada in 1952. She'd pressed it into my palm the week before she died when I was 22 and had just passed my CPA exams. She told me it was for the woman who would carry the family's stubbornness into the next generation. The ring had gone missing from my jewelry box in our Leslieville house 3 days earlier. My husband had told me he hadn't seen it. Below the image, a message. He said you wouldn't show up tomorrow, prove him wrong. The wheels touched the tarmac with a soft jolt. I sat with my hands folded on my lap. I did not cry. I pulled up the non-emergency tip line I'd used when I'd filed the original theft report and uploaded the photograph as new evidence. I hit send before the seatbelt sign went off. She was waiting at the baggage carousel. She was wearing a designer coat I recognized. I had seen the receipt. Because for the last 3 years of our marriage my husband had submitted his personal credit card charges as corporate expenses for my firm to reconcile. She walked toward me the way people walk when they've rehearsed what they're going to say and are looking forward to delivering it. She pushed an envelope against my chest and told me my husband wanted me to have the mediation papers the moment I landed. She said he'd added $5,000 to the offer as a gesture of good faith. She said I should think hard about what I could realistically afford. I looked at her hand, at my grandmother's ring. "I won't be signing anything," I said. She said some things after that, about my appearance, about why my husband had made the choices he'd made, about what kind of woman builds a career instead of a family. I listened to all of it with the same attention I give to a spreadsheet that doesn't balance, steady, clinical, waiting for the part that matters. "That ring belonged to my grandmother," I said when she finished. "I filed a theft report with Toronto police 3 days ago. I updated it 40 minutes ago with a photograph of you wearing it. Receiving stolen property is a criminal offense under the criminal code. I'd think carefully about what you do in the next few hours." Behind her, my husband's property manager materialized from the arrivals crowd and stepped into my personal space. "That's enough." Malcolm's voice was not loud. It carried the way the voice of someone carries who has spent decades speaking in rooms where the loudest person is always the least important one. He stepped forward steadily, his cane clicking on the tile floor, and he looked at the property manager with an expression of absolute unconcerned authority. "Step back from this woman," he said. "Now." The man stepped back. I watched it happen. Malcolm offered me his arm. "My car is just outside. Will you let me drive you to your hotel?" The town car was warm. We were on the 401 heading downtown when my husband called. He didn't say hello. He told me that his lawyer was Reed Sinclair, that Reed Sinclair did not lose family law cases in this city, and that if I showed up tomorrow without signing those papers, the next 2 years of my life would be something I'd need a long time to recover from. I ended the call without answering. Malcolm was looking out the window at the city lights. "He sounds less like a man who is confident," he said, "and more like a man who is afraid of what you've already found." "He should be," I said. I opened my laptop. "Can I show you something?" We spent the drive going through what I'd built, the numbered company, the Oakville property transfer, A consulting firm registered in his business partner's name that had received $1.9 million in wire transfers from our joint corporate accounts over 14 months, with no corresponding employees, no website, no legitimate business activity. The transfers were described in the ledger as professional service fees. Malcolm listened carefully. When I showed him the mortgage documents, he asked me to scroll to the last page. I did. There was my name on the guarantor line. There was a signature that was not mine. I never signed this, I said. I have never seen this document. I know, he said. He had seen me sign a receipt outside the car when we stopped for gas. He had been paying attention. The pressure pattern in the final letters is inconsistent. This is a forgery. He was quiet for a moment. This is not merely concealed assets. A forged signature on a mortgage guarantee is a criminal matter. And the purpose is clear. If the Canada Revenue Agency ever audited these transactions, they would find your name as guarantor on the document that moved the money. They would have every reason to believe the scheme was yours. The city moved past the windows. I said he was going to let me take the fall. He designed it that way, Malcolm said. 8 years of your financial expertise and his final use for you was as cover. I opened a new document, chain of custody, date, source, method of access, authentication. Malcolm dictated the structure, and I built it while the driver navigated downtown, tab by tab, page by page, hidden assets, forgery, wire transfers, corporate fraud, everything with a source note, every figure cross-referenced against a public K filing confirmation or a corporate registry entry I was legally entitled to access. Before I got out of the car, he said, "Tomorrow, let his lawyer speak first. Let him lay out his entire argument on the record before you say a word." I printed until 2 in the morning. The hotel printer jammed twice. The room coffee was terrible. By 4 a.m. I had a binder with 4 color-coded tabs and an index, and every document had a chain of custody note and a source reference that could withstand a production order. At 6:47, a voicemail from my husband. His voice was cheerful in a way that made my stomach turn, the particular lightness of someone who has already counted their winnings. "Morning, Willa. Reed's going to make this very simple today. Don't embarrass yourself." I listened to it twice. I sent back a single text. "I balance books for a living. Yours are overdue." I picked up my binder and left. Reed Sinclair's firm was on Bay Street, the kind of office with marble floors and the specific curated quiet of money that has been in one place for a long time. My husband was already in the boardroom when I arrived, leaning back in his chair the way he sat when he'd already decided an outcome. He looked at my binder and smiled. Sinclair slid the settlement package across the table, $20,000 full and final. He told me I was an unrepresented party walking into a dispute against a firm with 30 years of practice in this court, and that I should consider my options carefully. His tone was the tone of someone explaining something to a person who couldn't be expected to understand it. I pushed the package back across the table and opened my binder. I went through it the way I go through any audit, methodically, calmly, one figure at a time: the numbered company, the Oakville transfer, the consulting firm, the wire transfers traced against the timeline of the divorce filing, the forged mortgage guarantee, the discrepancy between what my husband had disclosed in his sworn financial statement and what the corporate registry and CRA filing confirmations showed. My husband's color changed somewhere around the 4th minute. When I finished, Sinclair leaned back. He told me I'd done impressive work. Then he told me I had a serious problem. The records from the consulting firm's filing history had come from a protected corporate database, and without a court-issued production order, everything in the binder might be inadmissible. I had conducted an unauthorized search. He referenced Justice Holbrook, the judge assigned to our file, with the particular warmth of a person who sees that judge regularly on a golf course. "If I move to exclude this evidence tomorrow," he said, "Justice Holbrook will grant the motion. I'd encourage you to reconsider the offer before that happens." My husband settled back in his chair. He was smiling again. I stood up, I took my binder, I walked out. My phone was lit up in the lobby. A message from Malcolm: "I reviewed your documents last night. Meet me at the Tim Hortons on Adelaide before 8. I found the gap in his argument." He was in a corner booth when I arrived, a coffee already on the table for me, his suit a quiet charcoal gray. I told him everything. Sinclair's motion, the argument about unauthorized access, the mention of Justice Holbrook. Malcolm nodded once. He reached into his jacket and set a single document on the table. It was a Court of Appeal for Ontario decision. The highlighted passage was clear. In family law proceedings, the duty of full and frank financial disclosure overrides confidentiality claims regarding business records when those records demonstrate deliberate concealment of marital property. Documents received at a matrimonial address are accessible to both spouses under the disclosure framework. A judge could not suppress evidence of concealment without effectively permitting that concealment to stand. Sinclair is treating this as a charter search and seizure issue, Malcolm said. That framework does not apply here. Family court operates under the family law rules, and those rules impose an absolute disclosure obligation. His motion is based on the wrong body of law entirely. And if Justice Holbrook tries to grant it anyway, I said. Malcolm looked at his coffee. Then he will be doing so on the record, in a courtroom where the Ontario Judicial Council is represented. I looked at him for a long moment. Malcolm, who are you? He folded his hands. A retired business law professor, he said, who spent 20 years before that on the Court of Appeal for Ontario, and who currently serves in a volunteer capacity on the Judicial Council, the body responsible for reviewing conduct complaints against judges in this province. He paused. I also served 2 terms as treasurer of the Law Society of Ontario. Reed Sinclair appeared before me in a discipline matter during his 2nd year of practice. He will recognize me when he sees me. I thought about my husband in the courthouse hallway, laughing. Shall we? Malcolm said. The courthouse on University Avenue was all stone columns and echoing marble. My husband's group was already in the hallway when we arrived. Him, Sinclair, his mother, and the woman with my grandmother's ring, loose and confident, waiting for a verdict they'd already decided. My husband saw us coming and said something behind his hand to Sinclair. Then he called out, loud enough to carry, "Is that your lawyer, Willa? Did you actually show up with someone's grandfather?" His mother laughed. Sinclair glanced at Malcolm the way people glance at things they've already dismissed. Malcolm did not look at them. He looked at me. Ready, he said, and we walked through the courtroom doors. Justice Holbrook was reading something on the bench when we entered. He looked up at the petitioner's table, me, no counsel listed, and made the expression that judges make when they've already decided a hearing will be brief. Sinclair was on his feet immediately. He was impressive, confident, precise, citing cases by name, landing each reference with the ease of a man who has made this particular argument in this particular courtroom and won it before. He mentioned Justice Holbrook's name with the warmth of a colleague. He moved to suppress the binder, dismiss my financial claims, and enforce the settlement. He sat down. Mrs. Willa, the judge said, "Do you have a response to the motion?" "She does," said Malcolm. He rose from the front row of the gallery and came through the partition gate with the unhurried steadiness of a man who knows exactly where he is going and exactly why. His cane marked each step in the silence. I watched Justice Holbrook's face. It changed in stages. Recognition first, then something more complex. A rapid reassessment, a recalibration of the room. His pen stopped moving, he straightened fractionally. When Malcolm reached my table, the judge cleared his throat in a way that was completely unlike his earlier manner. Justice Grier, the address was careful, almost tentative. I had no idea you were involved in this matter, sir." Sinclair had gone perfectly still at the respondent's table. Malcolm stated his request to serve as my legal advisor. Justice Holbrook granted it before the sentence was complete. I presented the Court of Appeal decision. I walked through every document in the binder, its origin, its source, why each was legitimately obtained. I explained, clearly and without performance, why Sinclair's motion was grounded in the wrong legal framework, why the family law rules disclosure obligations rendered the motion not only incorrect but, given the evidence of deliberate concealment, an attempt to use procedural tools to shield fraud. Justice Holbrook denied the motion. He admitted the binder in full. Sinclair did not speak. My husband took the stand. He was sworn in. He answered my questions with the controlled precision of a man trying very hard to maintain control. It lasted about 15 minutes before it stopped working. He admitted the numbered company. He admitted the Oakville transfer. He said the consulting fees were legitimate expenses, his voice climbing as he said it. When I showed him the mortgage document and asked whose name appeared on the guarantor line, he said mine. When I asked whether I had signed it, he said it was a standard administrative matter, and I was being deliberately obstructive. Justice Holbrook asked him to answer the question directly. My husband said, she would have agreed if I'd explained it to her. It was for the business. I built that company. I was not going to let a divorce filing take apart everything I spent 8 years constructing just because she... He stopped. The courtroom was very quiet. Justice Holbrook set down his pen. He looked at the documents. He looked at Malcolm. He issued an emergency asset freeze covering both numbered companies, the Oakville property, all associated accounts. He awarded equalization of net family property based on the full disclosed asset value. He referred the mortgage forgery and the wire transfer pattern to the Crown Attorney's Office for review under Sections 362 and 380 of the Criminal Code. My husband's mother stood up from the gallery and began shouting. She got 4 sentences out before she was held in contempt of court and escorted from the room, her voice fading down the hallway until the heavy doors swung shut. Sinclair packed his briefcase. He walked past Malcolm and did not say a word. My husband was arrested in the hallway 20 minutes later, not for the fraud, which would take longer to process, but for the theft. 2 Toronto police constables, polite and unhurried, asked him to come with them. He looked at me across the hall with an expression I had never seen on him before, and I understood that he was looking at the collapse of the story he had been telling himself for 8 years. The woman with my grandmother's ring was near the exit doors, already on her phone. When the officers approached her about the reported stolen property, she had the ring off her finger before they finished the second sentence. She held it out without being asked. I put it in my coat pocket. I didn't say anything to her. There was nothing left to say. Malcolm was waiting by the elevator. We rode down in silence. Outside, April in Toronto had that specific quality. Cold and bright at the same time, the air sharp with the smell of the lake and something just beginning. He handed me a card before his town car came. A forensic accounting firm, one of the largest in the country, with offices on Bay Street and in Vancouver. On the back, in small, precise handwriting, call me. We have been looking for someone like your caliber for 2 years. You called her last night, I said. I reviewed your evidence binder at 11, he said. I called her at 11:30. She was still at the office. He shrugged, just slightly. Good forensic accountants usually are. 3 months later, I signed my name, my actual name, with my own hand, on a partnership agreement 43 floors above Bay Street. The window looked west over Lake Ontario. My grandmother's ring was on my finger, exactly where it belonged. The final equalization payment had cleared the week before. The Oakville property had sold. The criminal matter was proceeding slowly through the system, as criminal matters do, but it was proceeding. His mother had paid her contempt fine and returned to Oakville, where I was told, by people who still moved in those circles, that she was not speaking to anyone who asked about her son. I had a lease on a condo in the annex, a coffee maker, a small cat who had claimed the east-facing window as his own and was not interested in negotiating. I thought sometimes about what it had cost me to build a life that someone else could quietly fold into his own. My income, my expertise, my name signed to documents I'd never seen. 8 years of 70-hour weeks so that he could stand in a boardroom and talk about what he had built. I thought about what it had finally taken to stop being useful to him and start being something he couldn't manage. The answer was one delayed flight, one man who had forgotten to eat breakfast, and the instinct, old, deep, trained into me by years of auditing other people's secrets, to keep looking at the numbers until they told the truth. Some debts come due on their own. You just have to make sure the records are in order when they do.